Hi guys, welcome back to Battle with Ola. This is Mujola Olua, and it's a lovely day for us to talk about the thought of nuisance because someone has asked that we talk about it. So this is a Ask Me Anything Legal video. In case you're wondering what Ask Me Anything Legal AML is on the channel, it is the medium avenue that we have created for viewers and subscribers to ask topical legal questions that we can make an entire video around. So if you have a question that you think needs an elaborate answer that many people will benefit from, you ask it in the comment section, preferably after you've watched the video, and then you ask for that particular topic or issue or video to be made. It could be related, most likely it should be related to the video that you've just watched, or even if it's not related, if it's something that you believe that more people will benefit from, you ask it, and if we find it so, we make a video for you, we make a video for everyone on that topic. So someone asked if we had done anything on public or private or on nuisance, and I decided that let's talk about nuisance today. So this is a video on nuisance. We're going to be talking about the thought of nuisance. We're going to be talking about public nuisance, private nuisance, as the case may be. Probably in the coming days, we're going to take some decided cases that deal with nuisance. But today, we want to just discuss the topic, what it is, how it is proven in court, the damages, the reliefs that are awarded, what a person claiming nuisance needs to show, what they need to do, and the liability that the perpetrator bears or carries. So that's what we want to talk about. Don't forget to like the video once you've seen it, and don't forget to leave comments in the comment section to continue the conversation. Always click on the topic area. That's where that's what leads you to the description box where you see all the other goodies that we have for you on the channel. Thank you for always watching Battle with Ola. The word nuisance is used to refer to something that causes offense or that causes harm or injury. So initially, it originated from the Latin word or Latin term nocere, N-O-C-E-R-E, which means to harm or to injure someone. So it was usually used to depict a grave or serious injury, but over the years, the seriousness of the injury that nuisance depicts or connotes has been watered down. But in law, nuisance is more than that. So what it really means is the interference caused by one person to another person's enjoyment of their right. So this is A and this is B, like we used to do. So if A interferes with the right of B, that is nuisance. That is B's right to enjoy B's property or to enjoy some other maybe possession over a landed property, over a building, over a residence, then we say that, or over some other amenities. So essentially, A is interfering, and unreasonably so, with B's right of enjoyment of a certain other right. Then we say that A is committing what is known as nuisance. So it could be a tort and it could be a crime. Usually when it's private, it is a tort, a civil wrong. But when it's public, it can be both. But when it's public, it can be a tort and a crime at the same time. That is what nuisance is. Nuisance can come in form of noise, pollution, odor, obstruction of a right of way, as the case may be. I dare say that in my years of practicing law, I have probably witnessed all types of nuisance, and much so, even in my private practice and when I was working with the government, when I was a mediator at a government facility, I witnessed all sorts of nuisance complaints. Some I mediated, some my colleagues mediated. I've talked about some of them on this channel, and I'm just going to be giving examples as we go. So we talked about what nuisance is. There are two types. There's private nuisance, there's public nuisance. When the nuisance is affecting the generality of the public, it is public nuisance. What examples can you think of off the top of your head? You can leave them in the comment section. If, for instance, someone is blaring noise, maybe a nightclub has opened in a residential estate and they are blasting noise, disturbing the entire neighborhood. It could be public nuisance because it's disturbing a large number of people. it could also be private nuisance to the buildings that are directly beside the nightclub. So you just need to know what it is, or whether it's private or public when you're trying to take action as a victim of nuisance. So when it's private, it means that it is affecting a person or just a few people. But when it's public, it's affecting, a wider generality, a wider sphere, and a larger number of people. So that's how to determine public and private nuisance. For public nuisance, there are the government usually would punish public nuisance. I said it could be a crime and it could be a tort. So you could file it as a criminal complaint, and it can be prosecuted by the government through their prosecutorial agencies, or you could file it as a tort, and the government could take action. There are specific agencies that take action on public nuisance. There are agencies that take action on nuisance that affects the environment, say maybe water related, land related, air related, sound related. There are places where you can report this in different states across Nigeria and wherever you're watching from in the world. So those public agencies usually redress public nuisance. So you just need to find out which agency is responsible for this and file a complaint, and they will do the needful. For private nuisance, you can file a civil lawsuit, and if it affects, a bunch of people, they can come together and file a class action. If you have watched the movie Erin Brockovich, you can see that that nuisance affected, a large neighborhood, and then they came together and filed a class action, because the factory was emitting waste that was polluting their water and causing them serious damage. That will lead us to how to prove nuisance. What are the things that you need to prove, the things that the court needs to see, or that you need to, as a person, be able to identify this that has happened. I think I have a case in nuisance. Let me go to court, or let me go see a lawyer. Here are those things. The court would ordinarily look at whether you had the property before the nuisance, or the nuisance came to you, or you came to the nuisance, essentially. So if you're complaining, for instance, we had a complaint when I was a mediator, that a man had come to complain that a church was disturbing them with their noise for their services. They have services during the day, during the night, so the noise was disturbing the neighborhood. So he had filed a complaint. One of the first things that I asked my colleague who was handling the matter is, did this man come to the church, or did the church come to that neighborhood to meet the man? That's one of the things that the courts will look at, because it is presumed that if you are coming into a place and the nuisance is already in existence, you know what you're signing up for. So either you weigh your options and decide, do I want to live here? Can I live here? Can I bear this? It doesn't completely, exonerate the nuisance committing party, but at least it sends a signal that you knew what you were signing up for. So because there was another case that we handled where I'd asked them that, okay, before a man had complained, it was a tenant in a building, he was already a tenant in a building, and then the landlord rented out the shops attached to the building to a tailor. So the tailor had a partner who was doing embroidery for him. So he sold the clothes, the partner would make the embroidery clothes. So the two men were working together, and this tenant in the building to which their shop was attached had complained that they worked late into the night running their generator, and it was disturbing him. So one of the questions that I asked was that, were you a tenant in that building before they rented the shop to these tailors? Of course he was. Then I had to find out when they were renting the shops to them, and you knew what they were going to do, because I think he had said that, the landlord had told them that, okay, he's renting to, okay, no, he had said that he met a tailor when he rented the building. Yes, I remember it correctly. Now, it's been a few years, so I'm juggling my memory. Now I remember it correctly. He said that he met a tailor, a particular tailor, when he rented the building. Then the tailor moved out, and then these people now came in. So essentially, he met the nuisance, so to speak. But his contention that day was that the former tailor did not make so much noise, did not work late into the night, and so on and so forth. But let's not go into the details of that case. I'm just trying to show you the example. The court will consider who came first, you or the nuisance. Then the court will consider how reasonable is the activity you're complaining of. This person, like now a church activity, how reasonable is the activity? So that is, will a reasonable man consider their activity, unreasonable or reasonable, bearable or unbearable? So if, for instance, now you're complaining that your neighbor mows their lawn, maybe they mow their lawn, lawnmowers can be very noisy, maybe they mow their lawn once a month or twice a month, and then you file a complaint of nuisance. We'll look at it that reasonably, any reasonable person, the man on the Clapham omnibus man, can or should mow his lawn, once in a while. And this is just, it's noisy, but, it's curtailed in a way. It's not prolonged, and it's not an everyday noise. So it's something you should be able to bear, because the court has held, that people should be able to get accustomed to some certain level of interference or difficulty or disturbance in their everyday lives. So you shouldn't just come to court at the slightest inconvenience. But let's say that your neighbor came into the property beside you, and then they started running their loud generators morning till night every day. No other person is doing that in the neighborhood. You can file a complaint for nuisance, because now they are committing noise pollution, air pollution at the same time, and it is not a reasonable activity because it's a residential area. Probably you even have but they've decided that they want to go off grid. Something like this happened to me. I wanted to record a video, the video that I did on SL Akintola and FUIM. I wanted to record it last week, but I was in my other apartment, and then our neighbor was running a generator, or about two neighbors were running their generator, because in Nigeria there's a shifting of some areas from band this to band that electricity supply. So I had to ask what's going on. So apparently they could not afford, or they were protesting the high tariff, so they decided to go off grid and start to run their generators through the day. So I could not record my video even though there was light, and I had my own gadgets and everything, because the noise would be too much. I'm just using that as an example. I'm not saying that I took offense or I decided that it was nuisance. Of course they shut it down at some time, but those periods of time were the times when I would normally have recorded my video, because there was NEPA power supply. We have generator, but we run it when there's no light. There was light, so as presumably everyone should have light, and I should be able to enjoy some peace and quiet to record my video. But alas, they were going off grid, or they went off grid, and then they were running generators when there was light. So it conflicted with my own timetable. I couldn't record the video until this much later. So the court will consider the reasonableness of, or the unreasonableness of, the activity that is causing the nuisance. Then the court will look at, is it a necessary activity? Is it a beneficial activity? The court will look at that as well. So we've looked at about three things now. We've looked at, the court will look at who came first, the nuisance or the complainant. The court will look at the usefulness of the activity causing the nuisance, the degree of harm, essentially, and then the court will look at how reasonable it would be or unreasonable to an ordinary person. So if you're able to determine or decide that I came before this nuisance has come to meet me, and now it is unreasonable even to an ordinary person, and the activity is not beneficial, you can make a complaint or file a civil suit. There are a few defenses to the tort of nuisance as well. Those are things that the the perpetrator can come under as a defense to your claim or your complaint. We have a handful of them. One of them is contributory negligence. So if the person can claim that you are also contributing to the nuisance by your activity or your omission in a way, you might not succeed in an action for nuisance. Contributory negligence is a defense. Another defense would be prescription. Prescription means that you have endured the nuisance for so long that the perpetrator now assumes that they actually have a right to do it, or it's okay for them to do it. So that is one thing. Another one, maybe for instance, you moved into a building where there's a primary school, and buildings are not soundproofed, and so every morning when you wake up, you are hearing good morning Jesus, good morning Lord. At about midday, you are hearing good afternoon sir, you are welcome to primary 2B, God bless you sir and your family, amen. Or you are hearing A for apple, B for ball around 10 p.m. 10 a.m. and then by 3 p.m. you are hearing now the day is over, night is drawing near. So you're basically schooling with them, but you're not a pupil. And maybe this has gone on for about 3, 4, 5 years. And then one day you wake up and decide, I don't want this kind of noise. How dare you disturb my right? This is a residential place. I have a right to enjoy peace and quiet in the property that I've built or that I have rented. And then you make a complaint or you file an action. Now, the authority you're complaining to, or the court, if you filed an action, we look at, you have lived there for 3, 5 years. Why didn't you complain all this while? So now, what do you want the school to do? To move away for you after living with them for 5 years? So it's basically like saying there's been acquiescence, so prescription. If you have endured the nuisance so much so that the nuisance causing party has now assumed a prescription, that they now have prescriptive authority to commit the nuisance, that you have borne it with them for so long, then you may have to continue to bear it. So that is also another defense to nuisance. Another defense would be you coming to the nuisance, like I have said. So if you met them there, maybe you met a biscuit factory, and there are loud fumes, generator fumes, machine fumes, has been disturbing the neighborhood before you came. For instance, there was a time in Nigeria not too long ago, maybe 2 years ago, 3 years ago, where the unique selling point for most or many real estate agencies or companies was that, the land is 5 minutes away from Dangote Refinery, the land is 10 minutes away from Dangote Refinery, it's 20 minutes drive from Dangote Refinery. That was their unique selling point. And people were buying this land. Now, Dangote Refinery has begun operations. If it turns out that the refinery is bringing out, is emitting fumes, harmful fumes, or emitting noise pollution, or water pollution, or any other form of nuisance, it may be difficult for people who bought the land with that in mind, with that benefit in quotes in mind, which should not be a benefit anyway. It may be difficult for them to prove nuisance. Of course, there are other things that anyone can come under to claim a redress for such kinds of pollution. But you cannot come knowing that you bought this land because it was close to the refinery. You cannot come and say that, they are now disturbing me. No, you came. So if you came to the nuisance, you cannot really complain. If you came to the nuisance, you can hardly complain. There are, the court will look at each case, peculiarly. So you may have a case, but you may not necessarily have a case if you came to the nuisance. So that's another defense, coming to the nuisance. And the other defense I want to talk about is statutory authority. So if it's a statutory authority, for instance, maybe from 2 p.m. to 5 p.m. every Wednesday, there's a water truck that comes to deliver water, supply water to your government residential estate, or to your a government school beside you, or a government office beside you. And the truck makes a lot of noise, because they have to pump the water and all of that. So they block the road, they make noise, they emit fumes. 2 p.m. to 5 p.m. every on that particular day every week, or maybe bi-weekly, bi-monthly. You cannot really complain because they are fulfilling a government approved and government compelled obligation, and the court will also look at the benefits of the activity. So you may not be able to file a claim for nuisance in that instance. You just have to find an alternative. So bear in mind that the court will look at these things on a case-by-case basis. I recall now that I also had a case where I've talked about it on this channel before, where someone had complained that their neighbor was building something in his own compound, and they shared a fence. But the thing he was building was protruding, such that when she wants to sell her own property, it will reduce the aesthetic value of her property. So she filed a complaint. We tried to mediate that matter, but it could go to court for nuisance. And now the court will consider, the thing that the court will consider is, this thing that this person is doing, is it interfering really with your own natural and normal use and enjoyment of your own property. So you can try to imagine that kind of scenario. There was a time too that a woman had complained, that I had to mediate between her and her neighbors. She had claimed that the community children were playing football at a pitch near her house and they were disturbing her. All of the members of the community that she brought to the mediation center claimed that they were okay with the playing of the football, that everyone even joined the kids in playing football, and that because they were playing on that plot of land, that empty plot of land, they kept it free of miscreants and grass growth and harmful animals. So those are some of the instances that I've seen. Of course, several other instances. Nuisance is something that most likely occurs every day. So it's, you look around you, you see, oh, this person is interfering with my enjoyment. I also mediated a matter once where, a community had brought a man who was blocking their right of way. So essentially, there was a narrow, a trackable path beside his own house, but he was claiming that because people had access to that footpath, he was endangering his own building because robbers were rampant in that area, and there was a way they could hide along that footpath at night. So he erected a fence to block it, a gate actually. So you lock it at night, you open it in the morning. So the community had complained that he was interfering with their right of way. Their children want to go to school early. He wouldn't wake up to open the gate on time. Their children, other people want to come in at night, and he would have locked it before they arrived. So that was another instance of nuisance. So you look at several instances around you. The basic thing to look at is this thing interfering with my enjoyment of my own right, maybe proprietary rights, possessory rights, rights over my own property, over my own way, over my own apartment, So, and then is what they are doing, is it reasonable? Will any reasonable person agree or accept or endure it? So you look at those things. Also, who can you sue for nuisance? You can sue the person that is committing the activity, that is the originator. You can sue them. You can also sue the person that has a proprietary right over the property where the nuisance is emanating from. So if, for instance, a company's chemical waste is polluting the community river or water now, you can sue the company because they are lawfully the persons responsible for whatsoever is going on. You can sue the company owner rather, or the directors of the company, whoever is responsible for whatever is going on in the company, even though it could be that it is their staff, that is committing that pollution. So you sue the person that can answer for whoever is committing it. That is where you cannot sue the actual person that is committing the nuisance. So you go see your lawyer, they'll be able to help you weigh your options and decide what to do and how to go about it. What do you get out of a complaint or a claim of nuisance? You can sue for damages, monetary damages. You can sue for damages. That's you can get an injunctive relief. That is a relief, an order of court compelling the nuisance to be stopped, or the activity causing the nuisance to be stopped. So you can get an injunctive relief. You can also go by way of abatement. Abatement just means it's like self-help, but within the bounds of the law. That is, you are stopping the nuisance. For instance, if something, maybe someone's pets keep escaping into your property, littering your property with their own feces and their own wastes, you could erect a fence or you could erect you could build you could construct a flower fence, a tree fence, or a short perimeter fence to prevent those pets from coming in from your neighbor's property onto your own. That is abatement. You could also go on, maybe your neighbor's water is flowing into your own compound, disturbing you. You could just cross over to stop the water. Maybe for instance, your neighbor went out, they are pumping water. Now the water has overflown and your house is about to be flooded, but they are not there. You could cross and turn off the pumping machine if it's something that you can do. But that does not give you a right to trespass. Very important. I recall that when I was living in on the island, there was a time that My neighbor had gone out. She had gone to the mainland. I was living upstairs, I recall. I was living in the middle. There were 3 apartments upstairs, downstairs, and three downstairs, and my neighbor upstairs, had gone to the mainland, had turned on a tap, and what we had run out of water before she went out in the morning or afternoon. And then at night when light came and we were pumping water, our water was pumping, but people downstairs did not get water because my neighbor turned on a tap, went away. So all the water was just gushing into our apartment, gushing in, gushing in, gushing in, gushing in. So what we had to do was nobody could enter our apartment because it's a separate apartment and we don't have a key. And she had gone, we called her, she had gone to the mainland. There was practically no way she could come or even come in time that night. So we called the landlord. So he he advised us on how to he said he was going to send someone that was going to enter our property, our apartment on our behalf. Yes, that's what he said. So that would have been abatement if we had done that. It would not be trespass because we are trying to stop a nuisance. So the person would have entered through my own apartment. They had their way and they would have shut the water and then would have been able to pump and everyone would use water. So eventually we found another means when we waited on the landlord and he didn't send the person he wanted to send. We called him again and then he gave us a second option to store some water in pots and bowls and then stop the pumping till my neighbor would come. So so if we had entered into our apartment to stop the water, it would have been abatement. So those are some of the reliefs to nuisance, the thought of nuisance. Generally, nuisance is something that happens in everyday life. But you must also understand that if it comes to equity, must come with clients. So if you are doing something also, you cannot claim nuisance. So essentially, nuisance is something that happens in everyday life. You just need to understand what it is, what your remedies are at law, how to go about it, and where to file a complaint or a lawsuit. But essentially, you can also take the first step of ADR by notifying the perpetrator that they are disturbing you and they should stop what they're doing. So you take that first step, and if it does not stop, then you can take a further step to report to a government agency if it's public nuisance, or to file a civil lawsuit to explore, other government agencies to set up to mediate or to interfere and resolve private nuisances. I will see you in my very next video. I hope you learned a thing or two. In some other videos, like I said, we're going to be discussing some decided cases relating to nuisance. Don't forget to subscribe to Battle with Ola and bring a friend along. Toodles!